Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, and member of the United States Supreme Court Bar. If you haven't subscribed to the Four Boxes Diner and you love the Second Amendment, please subscribe. We really would appreciate it. All right, folks, here's the story. We've already talked a little bit about NYSERPA versus Bruin. We're going to talk a lot more about it coming forward. But what I want to give you is a quick rundown of approximately 6 Supreme Court cases that are pending right now. They're not being heard by the Supreme Court now. The court, though, is deciding whether or not to hear those cases, meaning the cases I'm about to describe are up for what's called certiorari. If the Supreme Court grants certiorari for one or more of these cases I'm about to describe, then the Supreme Court will hear those cases like they just did with NYSERPA versus Bruin, and they will hear those cases, including the briefing and oral argument and a decision during the 2022 to 2023 term that, again, will start this coming fall. Now, or if the courts decide not to take these cases, they can do what's called GVR them, and GVR stands for grant certiorari, vacate the lower court decisions that ruled against the gun owners, and then send them or remand them back to the lower courts for another consideration, another review by those lower courts in light of what the Supreme Court just articulated and laid out, including the new standard of review, which is really an old standard of review, in NYSERPA versus Bruin. So again, they would grant the case, grant cert to the case, vacate the lower court decision, and send them back for further information, further finding, or redecision based on the decision in NYSERPA versus Bruin, telling the lower courts, read our decision and reapply that law to these cases that are now in front of us. Okay, so here's the cases right now that we're waiting on certiorari. The first 2 cases involve magazine bans of over 10 rounds. One is based in New Jersey. The other is in California. The New Jersey case is Association of New Jersey Rifle and Pistol Clubs versus Growell, which is a New Jersey case, a challenge to New Jersey's ban on magazines that hold more than 10 rounds. A related case, although not legally related, but they're basically related in terms of the issue presented, is a case called Duncan versus Bonta. You people in California know all about this. This is the decision against gun owners supporting the magazine ban, saying you can't have magazines of more than 10 rounds in California. Duncan versus Bonta. The Supreme Court has to decide whether or not to send these cases back to Maryland and California for further, reconsideration, given the Bruin case, or will the court take these and decide them next term? We will see in those 2 cases. The next case, which I'm guessing is almost certainly going to be GVR'd and sent back to California, is a case called Young versus Hawaii. This got a lot of attention by the anti-gun community that basically upheld Hawaii's open carry regime. But then, given the Supreme Court has just decided that concealed carry shall issue regimes at a minimum have to be honored across the country, including in Hawaii, which is one of our 50 states, I have a feeling the Supreme Court is going to simply grant cert, vacate the decision in Young versus Hawaii, and send it back to the Ninth Circuit for further to basically be redecided. The third and the fourth and fifth cases also are related. They're both bump stock cases. These are not actually technically Second Amendment cases. One came out of the 6th Circuit and one came out of the 10th Circuit. One is called Aposhian versus Garland, and the other is Gun Owners of America versus Garland. Again, Gun Owners of America versus Garland, and Aposhian versus Garland, Garland being Merrick Garland. Both of these cases involve the bump stock ban during the Trump administration that said, and if you remember the way they did it, Congress didn't pass a law banning bump stocks. The ATF said, we have the authority to redefine these pieces of plastic, these bump stocks, to be machine guns because they fire automatic rounds, blah, blah, blah. Really, it's an absurd legal argument. It makes no sense. It should not stand up. But again, the law doesn't always make sense, and people don't always make the right choices, in my view. But the bottom line is we're waiting to see if the Supreme Court will take these 2 bump stock cases. If they do take it, it will not technically be a decision on the Second Amendment. It will be an administrative law decision but we still will have the effect of being very good for gun owners, but not technically Second Amendment cases, because in these 2 cases, if the Supreme Court rules in favor of what I would say the gun owner position, they would say that the ATF's powers and authority must be dramatically reduced because they exceeded their authority under the federal statutes that give them authority, and that would be very good because it would basically make it much harder for ATF to legislate and restrict gun owner rights through regulation, which has been going on for quite some time. So those are the main cases. The other case I want to bring to your attention, the last case is called Bianchi versus Frosch. This is out of the Fourth Circuit, which is Maryland. This is a challenge to Maryland's assault weapon ban. Again, I think there's a good chance that the Supreme Court may send this back to the Fourth Circuit to be redecided in light of the Bruin case under the new standard. But I also think there's a good chance that the Supreme Court may take this case because I actually think so-called assault weapon bans are very easy cases to rule in favor of the gun owners because, as you know, of the common use that the test for protected arms, meaning what is an arm that's protected under the Second Amendment, is an arm that is commonly used or commonly possessed by law-abiding Americans for lawful purposes. We know that AR-15s are used by tens of millions of Americans for lawful purposes. And if you compare that to the 2016 Supreme Court case in Caetano versus Massachusetts that said that stun guns are protected arms under the Second Amendment because they're owned by approximately 200,000 Americans for lawful purposes. Well, if stun guns are protected arms by the Supreme Court's view of the Second Amendment, it's almost certainly the case that AR-15s would be also protected, and thus bans on AR-15s, which is being challenged here out of the state of Massachusetts, out of the state of Maryland, will almost certainly be struck down. I just hope it's done now by the Supreme Court and not sent back to the Fourth Circuit for further consideration. Okay, these are the cases I want you to look out for over the next 7 to 10 days. These are the hot ticket items now that Bruin has decided. And again, we'll be talking to you a lot more soon. And if you haven't subscribed, please do so. And again, we'll see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.